My name is Karen Lee Pollock, and I'm often asked by people, is all hope lost if I have overstayed my visa or I entered the United States illegally? And the question is no, provided you satisfy certain criteria. Section 245I is a little known provision that allows people to stay in the United States if they entered illegally or overstayed, provided an immigrant visa or labor certification was filed for them on April the 30th, 2001 or on January the 14th, 1998. You had to be present in the United States at the time. You would pay a $1,000 fine, and as long as your prior petition was approvable when filed or your labor certification was approved, you can now file an immigrant application based on employment or family or based on the diversity visa, as long as you can provide evidence that you filed a petition during those dates that was approvable when filed. In addition to covering you, this will cover all immediate relatives, such as spouses and children, if you were married at the time you filed the application in 2001 or 1998. It will also benefit your spouse or children even if you are now subsequently divorced. So, assuming in 2001 a petition was filed for you and your spouse, you subsequently got divorced, and now your spouse, 10 years later, wants to file their own immigrant petition based on a new spouse or based on a child, they can, and they can rely on your application that was filed in 2001. Unfortunately, though, Section 245I does not cover relatives who are after acquired. So it does not apply to children who were born after you filed your 2001 application or 1998 application, and it does not apply to spouses who you married after the time that you filed the initial application. This is a really useful way to obtain an immigrant visa where you are out of status because you overstayed your visa or you arrived in the United States illegally. There are some tricky aspects to this visa. If you have questions regarding Section 245I, please feel free to call me.